May it please the court. Good morning. My name is Bob Rock. I represent Medco with my law partner, Jonathan Spar. We believe that the trial court, and Your Honor, I'd like to reserve 5 minutes, please. We believe that the trial court actually erred in finding that my client, Medco, was a holdover tenant because it is undisputed that Medco had a bona fide claim or right to possession of the subject property. This is a 125,000 square foot office building located in Hidden River. Glen acquired the property after the lease had already been negotiated with another tenant, SBC Telecom. Medco actually was the assignee of that lease. That lease provided a mechanism after the initial term had expired for the parties to have two renewal options, 5 years. The initial lawsuit that was filed against Medco was for a determination, a declaratory judgment action to determine what the renewal rent should be. And the purpose, of course, in initiating that action is the parties understood that the renewal option had been exercised by my client, Medco. A second amended complaint was filed actually in August of 2010. The second, that amended complaint not only sought a declaration again to determine what the renewal rent would be, but also breach of contract, challenging the determination of prevailing market rent that was included in the option renewal provision of the lease. Those first two complaints never mentioned holdover rent. So over 3 years went by of litigation, and the issue regarding holdover rent never came up. The first time that holdover rent was ever even raised by the landlord was in October of 2012 when the second amended complaint was filed. That's significant for several reasons. The lease is very specific as to what constitutes an event of default. Specifically, paragraph 20A of the lease sets forth specific conditions that have to be met before default occurs. And those conditions for payments of rent are obviously the failure to pay the rent, but the second requirement is a notice to the tenant and an opportunity to cure. That never happened. It's undisputed that that requirement under 20A never actually occurred. In fact, at the trial, Judge Wolf asked the corporate representative, Mr. Bobek, "Sir, did you send the notice?" The answer was they did not send the notice.
Why is it not a futile act? It seems clear to me that your client had no intention of paying more than $14 a square foot.
Well, and Your Honor, that's not the case at all. And let me explain why. We actually, under the prevailing market rent determination process provided for in the lease, provided for an expert that testified that the market rent was actually less than $14. So the possibility existed that we would actually pay less than the $14 a square foot that was provided for in the initial term. The other very significant point, Your Honor, is futility was never raised in the court below. That issue was first brought up in this appeal. So I submit that that is not the case, and my client would have paid whatever the determination was made regarding the renewal rent.
But help me understand then.
Sure.
You sort of gave up that ghost when you later took the position that there was no renewal.
Well, we did, though, 2 months, all right, and it's important to give a little historical background here, Judge. The landlord had always taken the position that a renewal had occurred. In fact, in their initial, or the second complaint that they filed, they actually alleged that a renewal had occurred. When we deposed the corporate representative for the landlord, they took the position that a renewal had occurred. When the second amended complaint was filed, we were permitted an opportunity to depose the corporate representative again. That deposition occurred approximately 2 months before the motion for summary judgment was filed. Only then did they take the position that the renewal was ineffective. And so obviously, they took that position 2 months before. At the time that the case was actually tried, the issue regarding renewal had not been withdrawn. And in fact, up until the moment that a final judgment was entered on the renewal, my client had the exposure that they might be facing a renewal. So that issue, and that frankly kind of exemplifies the need for the notice.
My recollection was that much earlier than the trial, your client had taken the position that there was no renewal. I thought at the summary judgment hearing that was expressed.
Oh, absolutely, Judge. In fact,
so it wasn't an issue at trial. It was resolved at the summary judgment stage.
The summary judgment actually was, I think it was the week before we actually tried the case.
But at the point you went to trial, your client did not try to establish that there was a renewal. All we need to figure out is what is the proper renewal amount. You abandoned that.
Absolutely, Judge. Based upon what had occurred the week before at summary judgment, we did not raise the renewal issue at trial.
Somebody took a fair amount of risk in tactics in this case. And I think ultimately the question becomes, when the chips fell where they did, who suffers the loss? And it seems to me that had your client taken the position, there was a renewal and we did everything right, the other side jerked us around. And Judge, you need to tell us what the renewal rate is so we can stay there for our next 5 years. You might have won, but that wasn't the approach that was taken.
Well, Your Honor, the approach that was taken, and I submit...
And consistent with the wording of the lease, if there's no renewal, whether your client stays with or without permission, they're considered holdover for purposes of what the rent is.
Well, Your Honor, and that's where we respectfully disagree. And the way that we evaluated this, of course, and we expect that the court should have evaluated it, is that the law in Florida is absolutely clear that if there is a bona fide claim or right of possession, and that's exactly what the Covelli case says, the Green Acre Amusement case says, and Painter.
Different.
I'm sorry?
This lease is different. This lease provides that whether your client stays with or without permission of the landlord or consent, here's what you are going to pay unless you are still within the terms of the lease or the renewal term.
Well, Your Honor, I submit that the consent in 24B really is of no consequence. And in fact, even if you assume that that is correct, that you disregard Covelli, you disregard the Supreme Court's decision in Painter and the Green Acre decision, another fourth DCA decision, setting forth specifically that if there is a bona fide claim of right, you cannot be a holdover tenant.
But you've already taken the position that you abandoned that there was any lease renewal, that you had any right to be there after the expiration.
Well, but here's what those cases say. They say that it has to be fully litigated. In both the Painter decision, the Covelli decision, and the Green Acre decision, because...
Why do I have to fully litigate basically a concession that your client made that there was no lease renewal and, I should be out of there?
Well, and with all respect, Your Honor, until that is a final judgment, then my client is not going to know what the situation is and what the potential exposure is. But it also goes back to...
But your client knows what the potential exposure is because the lease tells your client what the potential exposure is.
Well, I submit that here, that's not the case, because the lease under 20A is very specific as to the notice requirement if there's a default. If you accept the position of the landlord...
The landlord... Does the landlord have to give a notice of default if the landlord is fat, dumb, and happy collecting 150% rent?
But the landlord never collected that rent. And
well,
so
the client didn't pay it.
But
it was entitled to collect it under the terms of the lease.
But only, Your Honor, this is my point, that the month after the expiration of the lease, if you accept that position occurred, we only paid $14 a square foot. which means that we were in default if you accept the landlord's position. In fact, the judge actually awarded default interest. So at that point in time, we were entitled to a notice under 20A that the $14 is not the rent you owe anymore. That never happened. That notice never occurred because they never took the position that it was a holdover. They took the position it was either renewal rent at prevailing market rent or holdover rent, but they were going to let the court decide, which is exactly what happened at the summary judgment.
But the complexion of the case changes when there's a concession that the lease has indeed expired. So we don't need to implement this process of figuring out the new rent amount.
But I submit if the landlord is seeking default interest, in which the court actually granted back to the day the initial term expired, then the only way the tenant would have known that that's the exposure, they had to send the notice under 20A. If they had done that, we would have an entirely different situation.
Would the court have been authorized, you were paying $14 as opposed to what the higher rate, and from the time that the lease expired, you should have been paying 150%, and therefore the interest would accrue on that delta, if you will, for the duration that you held over.
But the default interest, Your Honor, is only applicable if there is a default. The lease is very specific what the preconditions of default are, and the Hunt decision squarely addresses that. There's two preconditions: non-payment, notice, and an opportunity to cure. We never got the opportunity to cure. That never happened. So they didn't comply with the obligations under 20A without providing that notice. And Hunt is absolutely on all fours when it comes to the notice requirement.
Well, that may go to the default interest rate, but how does that go to the question of being a holdover tenant?
Well, the holdover tenant, and I agree with you, those are distinct, but if they are seeking the holdover rent, which, if you accept their position, was due on the day that we didn't pay them $21, then absolutely the lease is clear. We are entitled to notice of that. We never got that notice. That's the point. If they had given us the notice, we could have made the decision, stay, accept the 15, the 18, all those things. We never had that opportunity. That's why that notice is so critical. That's why it was negotiated in the lease, and that's why this case is so dependent on that particular fact.
Paragraph, let me see what paragraph number this is. Paragraph 20 talks about events of default.
Yes, sir.
Including a failure by the tenant to make any payment of basic rent on the due date and the continuation after the landlord has notified tenant in writing of such refusal. And then the default interest provision that's further down in there says that any amount that isn't paid, the landlord gets the default interest rate. And your position is until they issued a notice that you are not paying enough, then the default rate doesn't kick in?
Absolutely. And Your Honor, if you go to the definitional section of the lease, it actually defines that area, default interest, and it also defines an event of default under the definition section. And what the event of default does in the definition section is it refers you specifically to 20A. 20A, as you just read, has two requirements: the failure to make the payment, written notice, and an opportunity to cure. There is no record evidence that the requirements under 20A was ever met. And in fact, what the judge concluded is that the second amended complaint filed in October met the notice requirement. And I submit that that's going to turn the notice requirements under the lease upside down if that is the law. It is a negotiated specific requirement that was not met. Therefore, they cannot recover that holdover rent, even if the conclusion was it was a holdover tenant before they can get the rent they're now seeking is to go to 20A, which never happened.
And you're at the 15-minute mark if you want to reserve your 5 for rebuttal.
Yeah, I need to, Judge, to respond to the other issue. Thanks.
Good morning. May it please the court and counsel. I'm Suzanne Lebritt, and it is my pleasure and privilege to represent Glen today. The first point I'd like to address is the issue of renewal and what Medco knew about that. Medco knew before the lease expired in March of 2010 that there had been no renewal. And we know that not just because Medco said it in their motion for summary judgment, and I'd invite the court to look at their motion for summary judgment at page 9 specifically. They knew that the renewal procedure had unraveled when, and this I'm quoting from their motion, when the neutral broker got involved, Ron Ruffner. That happened, Mr. Ruffner got involved in the summer of 2009, and I would cite the court to his deposition testimony at page 15 and 16. That's in the supplemental record. Ruffner testified that he was never engaged and that he told both parties' brokers in 2009, before the lease expired, that he was out. He was the neutral broker whose job it was, in the event of a disagreement, to come up with the renewal rent. At that point, we all knew that there was a failed mechanism, that the rent couldn't be determined, that term was done.
So he was not engaged?
He was not.
And he did not render an opinion that the renewal amount should be $15 a square foot?
He testified that that's the number that he came up with, but he also testified that he was never engaged and that he told both parties' brokers that he would not formally opine. And I would cite the court for that to his deposition at page 10, 19 and 20, and 23 and 24.
Well, and at that moment, based on the lease terms, why are the two brokers that are one representing each side, why are they not selecting another third broker?
I honestly don't know why, and I'm not sure the record tells us, Your Honor, but I would submit to the court that the lease doesn't contemplate going to a third broker, to a fourth broker if the neutral can't.
If two brokers agree, we're going to hire Joe Smith, and Joe Smith says, no, thank you, are you suggesting that's it? The renewal option is done?
I think if we look at the literal text of the renewal provision, that's a fair interpretation of it, but...
That's a ridiculous interpretation of it.
I apologize, Your Honor. I don't mean to suggest...
If the two brokers select Joe Smith, and Joe Smith says, no, I don't have the time to do it, what you just suggested is then the tenant loses the right to renew.
I don't mean to suggest that, Your Honor. I mean to suggest that what the lease says is go pick a third broker. If the two brokers can't agree, that go pick a third broker. Here, the third broker came up with a number, communicated it to both sides.
Well, you can't have it both ways. Either he did the work or he didn't. And you said he took the position he wasn't engaged. So did he do what was contemplated by the lease to determine the prevailing rate?
I think he tried to, Your Honor, and I think the record would show why he chose not to be engaged was that, among other things, Medco refused to allow him access to the premises.
Okay, that's a different issue. What you said was he took the position he wasn't engaged, and I think the record supports that's what he said.
Absolutely, and I don't want to be unclear about the record. The record absolutely says that he took the position that he wasn't engaged, and that he communicated that to both parties' brokers, i.e. to the parties. They didn't take any further action at that point.
If the tenant wanted to stay on site, this wasn't really articulated, but it seemed to me if the tenant wanted to take the renewal and there was some failure, such as what you're describing, either party had the right to sue for some relief from the court saying, we want to stay and we've been thwarted, or your client says, they don't really want to stay and they're messing things up because they won't agree on A, B, and C. And that's what trials are made of.
And that's what our client initially pled. Because, of course, our client would have preferred a renewal. It's much more commercially stable from the standpoint of an institutional owner of real estate to have a renewal at a 5-year term. Certainly, that reason the holdover provision is in the lease is to afford the tenant some flexibility and to keep the landlord completely out of the hole in the event that a lease expires. The tenant's got a property with 125,000 square feet, a fully built-out communications center. 150% of that rent upon the expiration afforded them some flexibility to not renew. We would have preferred renewal, which is why we brought the deck action, and certainly this litigation stretched for some number of years, during which brokers were deposed and things like that. There certainly, and I believe that you hit the nail, Judge Silberman, right on the head when you said that Medco took a gamble, because that's exactly what they did. They knew, and they had a role in what broke down with the brokers. They knew that there wasn't going to be a renewal. They also knew what the parameters for the rental rate were, and what they did was they paid the $14 a square foot, gambling with the thought that if they could get us to concede to a rental rate that they liked, not what we thought was right, that they would have their renewal at a preferred rate. But the downside to that gamble, as you pointed out, was that what they were, and the lease was automatic. Upon expiration, paragraph 24, automatic mandatory rent increase to 150%. There was no renewal.
And your client's position is it could accept the $14 without indicating any further reservation of rights, and they would not be waiving their rights?
Your Honor, I don't know if that's a quite accurate statement of our client's position. Our client's position, and this is borne out by the record with regard to acceptance of the rent, I would, just give me a moment, I want to cite the court to the precise provisions. Peter Bobeck testified at transcript 63 and 111 that Apple Glen accepted the 14 as the payment, but never agreed to accept it as the final number, acknowledging that there was a dispute. And that testimony is confirmed, not refuted, by Medco's only witness, Mr. Tyler, who testified at transcript 100. We would continue to pay $14 as we worked to resolve the dispute.
So you both took a gamble as to what the rent was going to be post-expiration.
Your Honor, I would respectfully submit that my client took no gamble, because my client was traveling under a lease that said you can either renew, and this is the procedure we'll follow to get to the rent,
Well, I suppose.
or if we don't renew, and everybody knew what was in this lease on the holdover provision, you're going to be paying 150% a month, 150% of the rent, and that is commercially reasonable. And we didn't make a waiver on that. And I want to clarify something that was said.
What you suggested from those excerpts is that there was, among representatives, there was some understanding that there remained a dispute as to what that.
There was a dispute, and it evolved. The complaint was submitted twice, and I want to make a point about that, which is the question of when did the specific claim for holdover rent go down. It was said in appellant's argument, I believe, that the second amended complaint, which is specific and includes a claim for holdover rent, that was filed in the summer or in the fall of 2012. In fact, the second amended complaint, the proposed second amended complaint, which includes the holdover rent claim, was filed as a proposed amended complaint at R2-356. That leave wasn't granted on that until much later in 2012. But in March of 2012, the tenant knew that we weren't gambling anymore. We knew that we needed an alternative theory of something, that we didn't agree to keep this tenant in there indefinitely at $14 a square foot with no renewal term and whatever. They knew that, and they knew it in March of 2012, unequivocally. The holdover rent provision is self-executing. It's a contractual right.
That's what you seem to be arguing. Your opposition's arguing that notice is required for holdover rent.
Your Honor, I understand that that's their argument, and
Where
there
is
is
that
not
provision?
a provision in paragraph 20.
I'm looking for a provision in the lease where the tenant must be notified that you're going to charge holdover rent.
There isn't one. That's why you can't find it.
It seems that it's an automatic.
That is exactly correct, Your Honor. That's our position. And to the extent the tenant relies on the provisions of paragraph 20, which is where there's a condition precedent to a default, a monetary default during the life of the lease so that the landlord can exercise possessory or termination remedies, that's a condition preceding to a default during the life of the lease. not after the expiration, which the holdover is specific to. And this court, in the Cavelli case, this court can get this, is the general principle regarding construction of conditions precedent is that they're not favored. And I would cite the court to Cavelli on that. You shouldn't construe the paragraph 20, which has nothing to do with the holdover, as a condition precedent to the automatic operation in paragraph 24.
But let me ask you two questions. Did the trial judge conclude that there was a need for notice by suggesting that Second Amendment complaint was the operable notice?
I would submit to the court that I wasn't at the trial, so I don't know exactly what the trial judge thought or did or said. I mean, I know what he said from the transcript. But to the extent the trial court made the findings that he made with regard to notice, and I think the finding was that even if notice were required, the pleadings were de facto notice. If the trial court concluded that to the extent the trial court made that conclusion, I think that it was supported by the evidence. The pleadings themselves.
Your position would be going back to March.
And the notice was given in March unequivocally of the right to collect holdover rent, which is a contractual obligation to receive those funds. The statute of limitations on that began to run in March of 2010. We had till March of 2015 to sue for the holdover rent.
Well, let me ask it in the second question. To the extent the default provision exists independently of the holdover provision, what's the basis for the default interest?
For the default interest. Well, I would cite the court exactly to the provision of the default interest. And it doesn't require any notice. It is self-executing. It's in paragraph 2.
But there's no default once they're holdover tenants. I mean, see what I'm...
I understand your question. If they're holdover tenants, the obligation to pay the rent is automatic at 150%. My argument would be that default occurred in April of 2010 when they kept paying at $14 a foot. If the court would view the default not to have been perfected until March of 2012 when the pleading went down, saying we want holdover, then I could see an adjustment being appropriate on the default interest, although I would submit that would be an incorrect interpretation of the lease because the holdover rent became due automatically. The default interest provision operates automatically. There's no question about that. The text is clear to that provision, and it appears, I invite the court to read the provision. It appears at 20B Romanet 4 on page 24, and it says if the tenant fails to pay any rent or additional rent, interest payable at the default rate, is it either 15% or the amount specified in the mortgage? It doesn't say anything about interest. And it doesn't...
That is a subparagraph to section B, which says in the event of default, if any event of default shall have occurred.
Where it says that in paragraph 20, at the beginning of paragraph 20B, it is setting up the situation for the landlord to make a claim for possession or to terminate the lease. Our argument would be that the holdover rent was automatically due. And by not paying...
Let's assume we all agree the holdover rent was due. The question then becomes, do you get default interest, which under subparagraph 4, your argument is we get default interest because they failed to make the installment payment of any basic rent, which was the 150% amount. But that subparagraph falls within the entire paragraph of, in the event of default, here are the rights of the landlord. And so it read in context, it seems to support the other side's argument that you don't get default interest unless there's first an event of default and there's notice.
I understood, Your Honor. As a principal matter, I would default to the default began to occur in April of 2010. But as a secondary position and understanding the concern that Your Honor is expressing, if the court were inclined to view it in that realm, default interest would have to accrue from at least March of 2012, when the second amended complaint was filed, specifically demanding holdover rent pursuant to the automatic provision. Have I answered your question? Yes. I want to address one other issue, and it is that Medco, the whole reason for this notice, and it is always in these cases, is for the party to receive notice so that it has an opportunity to cure. And that argument in this case rings entirely hollow. Medco knew at the very latest in March of 2012 that we wanted holdover rent as a theory of relief. They say multiple times in their brief and in the papers that they filed in the trial court that if they knew we were going to ask for holdover rent, they would have moved immediately. But they didn't move immediately. They waited until after Judge Wolf signed this judgment saying they owed holdover rent. They didn't need an opportunity to cure, and if they did need it, and they really didn't think that the lease meant what it said, they knew in March of 2012. So the whole opportunity to cure, which is really all about what the notice is here, is an illusory argument, and it's a self-serving position advanced by the tenant to try to avoid its own obligations. Submit to the court that these are sophisticated commercial parties. We write these things down for a reason. Both sides took these things subject to an assignment. They knew what it said. They knew what it meant. Medco gambled with it. They got the downside of it. This court should affirm what the trial judge did. Thank you.
Judge Sleet, I'd like to discuss the question you raised regarding event of default. Specifically, under the definitional section, event of default makes reference to paragraph 20A. And our position is not only are they not entitled to default interest unless the requirements under 20A are made, but the damages that they are seeking is for breach of a lease agreement. And the notice requirements under 20A, just as the 4th District held in the Hunt case, mandate that 2 requirements be met. So we talked earlier, and Judge LaRose, I think you said we took the risk. Well, is it a risk when the written agreement that the parties had accepted as what would guide this relationship calls for specific requirements, notice and an opportunity to cure? So Medco understood that those requirements specifically set forth in paragraph 20A were never satisfied.
Well, let me ask, I asked opposing counsel a question on this, and there's, I think, a flip side of the argument, which is paragraph 20 contemplates default and notices of default, and then paragraph 1, I think, had to do with if there's going to be landlord's intention. This is subparagraph B1. You have to do these things if you want the landlord, it wants to terminate the lease, then subparagraph 1 says what you have to do. Subparagraph 2, whether or not the lease is terminated, notice to surrender. Then paragraph 3 talks about after repossession, here are some things that happen. And then paragraph 4 arguably is a standalone subparagraph because it says if you don't pay rent, you have to pay interest at a default rate. That, the way you're reading it suggests that the landlord actually has to elect to either terminate the lease or to cause a surrender. Otherwise, they don't get any interest.
And Your Honor, I don't believe it needs to be read that way. But I do believe that a default occurs when 2 conditions happen. And the remedies that are provided for in the lease, a precondition for those remedies is a default. And if the only way a default...
Paragraph B, which is the event of default, here's what the landlord's options are. It doesn't say in paragraph B, that opening line, anything about giving notice. It says you have to give notice, the landlord has to give notice if it intends to terminate the lease. Landlord has to give notice if it wants the tenant to surrender the lease. And then drop down a couple more paragraphs and it just says, if tenant doesn't pay, we get default interest.
Well, and Your Honor, though...
so you're reading into that opening B a notice requirement to trigger default interest, but it's not in that opening subparagraph B.
And I don't dispute that those words don't appear in subpart B, But what I do say is event of default, which is the triggering event for the payment of interest rate, makes specific reference to 20A, not 20B, 20A. 20A requires that the notice in non-payment and an opportunity to cure be given to the tenant. It didn't happen. And in fact, what's interesting about the argument that the landlord made, if you look at the record, the position that the landlord took at summary judgment is there is no default. There is no default. Well, if there is no default, they can't get default interest, and frankly, we agree that there cannot be default because the requirements under 20A must first be met. They haven't been met. So it rises and falls with their compliance under that provision. There is no dispute they didn't meet those requirements.
If we agree with you, is the landlord entitled to any prejudgment interest?
I don't believe, well, if you agree with me that, first of all, that this requirement under 20A must first be satisfied, then I would say absolutely the landlord's not entitled to any default interest, nor are they entitled to holdover rent until they put us on notice and an opportunity to cure.
For the sake of argument,
Yes.
if we reject your argument on holdover, but we accept your argument on notice of default being required to collect default interest, would they be entitled to any interest for the unpaid portion of the rent?
I think that it has to begin as the event of default provision requires when the notice and opportunity to cure occurred. That never happened. So the answer is no, they wouldn't be.
And you are at the end of your time.
All right, Judge, thanks.
Thank you.